Thank you for coming by. This is an American project. Please be sure to like and subscribe. We need a little over 300 subscribers to get to our 1,000 goal. All right, let's see what's going on. Bunch of madness everywhere. The Supreme Court agreed on February 28th to hear a second case concerning former President Donald Trump with the far-reaching implications for his 2024 court schedule. President Trump is facing 4 criminal indictments, the first of which will go to trial in less than a month, plus several other civil cases, all while campaigning for the presidency again with his eligibility still in question. Already on the Supreme Court's plate is whether President Trump can be disqualified as a candidate by individual states after the Colorado Supreme Court disqualified him for engaging in a J6 mess under a Civil War-era statute. This is what he did.
But you have to go home now. We have to have peace. We have to have law and order. We have to respect our great people in law and order. We don't want anybody hurt. It's a very tough period of time, but we can't play into the hands of these people. We have to have peace. So go home. We love you. You're very special. You've seen what happens. You see the way others are treated that are so bad and so evil. I know how you feel. But go home and go home in peace.
Experts say it's no secret that prosecutors want a trial before the general election and that President Trump all but avoids trial entirely if he wins re-election. The latest appeal the Supreme Court agreed to hear has to do with President Trump's presidential immunity defense in one of 2 cases, prosecuted by special counsel Jack Smith. President Trump was charged with 4 counts of conspiracy and obstruction for his actions on January 6, 2021, and pleaded not guilty. The case was originally scheduled to go to trial on March 4th, beginning jury selection just 1 day before Super Tuesday primaries across the nation. It has since been taken off the calendar, allowing a New York judge to move forward with scheduling a March 25th trial for President Trump in a case alleging he mishandled business documents. Last December, defense attorneys took the case to the appeals court after a U.S. District Judge Tanya Chutkin rejected a motion to dismiss based on presidential immunity. This stayed pretrial proceedings while the appeals court rendered its decision, putting the case 2 months behind schedule. The appeals court panel of 3 judges ultimately rejected the defense as well, but in an unusual order specified that a petition for a rehearing with the full bench would not result in a continuance of the stay. The mandate would only be withheld if President Trump appealed to the Supreme Court for a review of his defense within 6 days, the order stated. The Supreme Court had scheduled hearings for the week of April 22nd. Even if it decided swiftly to reject President Trump's defense and allow the case to continue in a district court, the parties would have to pick up from where they were back in December. This gives them roughly 3 months of pretrial litigation to go through before the case can be brought to trial. Meanwhile, the Supreme Court still has to issue an order and opinion regarding President Trump's eligibility as a candidate. Trump attorneys counted some 88 challenges across 45 states, citing Section 3 of the 14th Amendment. The argument these petitioners make is that January 6 constituted a problem President Trump participated in and therefore is ineligible to hold office again. As of February 28th, officials and judges in 3 states have found President Trump ineligible but stayed any order to actually remove him from ballots awaiting the High Court's decision. Recently, in Illinois, where ballots with President Trump's name have already been printed, a judge gave only a 2-day stay before election officials would have to void votes cast for President Trump unless appealed. The challengers have raised myriad legal questions, including whether Section 3 applies to presidents, whether states have the authority to disqualify national candidates, and the role of Congress in executing a disqualification. If the Supreme Court finds that Congress is the sole authority on executing Section 3, experts have predicted it may create other chaotic scenarios, with House members disqualifying him at any stage from the elections to ballot counting through legislation or a vote. And on the off chance that the Supreme Court decides to address the issue of whether January 6th constituted an incident, that would certainly provide case law for the prosecution or defense to cite in President Trump's other criminal and civil cases. President Trump's attorneys have also raised the presidential immunity defense in several other criminal and civil cases. Thus far, judges in civil, criminal, state, federal, and appeals courts have rejected the defenses, allowing cases to go forward. The Supreme Court has limited its review to only the question of presidential immunity from criminal prosecution for acts alleged to be taken while in office, but this is an area that the High Court has previously never addressed. Depending on the opinion issued by the court, Trump attorneys may then litigate presidential immunity with new case law in several of his other cases. All right, there you have it. Thanks for coming by. Please be sure to like and subscribe. I really appreciate it. And have a great day. God bless.